Good evening, everyone. I am CA Yamini Gujar, moderator of this webinar, and we are delighted to welcome you all in this webinar being organized by CCLEA, an NPO committee of ICAI. It is my pleasure to be a moderator in this webinar on professional opportunities in IPR for CAs on 28th August from 5 p.m. to 7 p.m. Been organized by Committee on Commercial Laws, Economic Advisory, and NPO Cooperative of ICAI. In short, while we are going to start with this webinar, till then, I would like to appraise you about the CCLEA and NPO committee. This committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge, dissemination, inputs to regulators on policy formation, to develop and publish technical guidance, background material, etc., and to create the awareness for professional opportunities for chartered accountants in the commercial laws and economic advisory and NPO cooperative. Our eminent speaker would be speaking on professional opportunities in IPR for the CAs in this webinar. I would like to introduce our eminent speaker, Ms. Neha Gupta. She is the practicing advocate, a qualified company secretary, and commerce graduate. During during her more than 13 years of professional career, she worked in top-notch consulting firm in India and currently acting as proprietor of Measures NRG and Associates, advocate and legal consultant. Initially she had been working with the initially, she has been involved in the vast range of professional assignments, including secretarial services, FEMA matters, and company law matters. Having deep interest in the intellectual property rights matters and issues, she pursued her career in this intellectual property rights since 2010 onwards. Her expertise lies in all the aspects of intellectual property laws, especially in trademark, copyright, design, and patent. She extensively and independently handles matter relating to filing, creation, consultancy, prosecution, litigation, mediation, rates, protection, settlement, and enforcement of above IPs in various court and forum across all over the India. Now, I would like to call Advocate Neha Gupta ma'am and means you can start with your session. We welcome you all. We welcome all.
Thank you, ma'am. Thank you so much for the lovely introduction, and thank you for inviting me here to speak on my favorite topic. Before coming to my slide, I would like to share that IPR, it's not just about legal. It is significant. It has significant financial, strategic, and business implication. Now, here I'm sharing my slides. Is it visible? I hope it is visible.
Yes, it is visible.
Thank you, ma'am. Thank you. Okay. So now, as I told, IPR is not just legal. It has significant financial, strategic, and business implication. And when we talk about these terminology like finance, strategy, and business, am I the best person to speak about in front of my CA colleagues? Now, come to my slide. And before telling what is the opportunities for CA in IPR, I would like to tell them what is IPR. Okay, what is intellectual property rights? Intellectual property, it's a creation, it's a product of human creation. Okay, whatever human creation can be tangible, intangible, but the intellectual property is purely about the intangible property. Okay, here is, I'm not talking about your car, your houses. These are the movable and some immovable properties, but here we are talking about only intangible property. And legal right vested with your intangible property, these are the standard of permitted action by law. They usually give the creator an exclusive right over the use for his and her creation for certain period of time. Why I am referring here certain period of time, I will tell you later. It is an intangible assets which can be sold, gifted, assigned, and licensed like any other property. Okay, here we discuss about these five variants and some other variants also of IP. I'm just sharing that patent, copyright, trademark, GI, and design. Okay, here is a Apple phone, and you can see there are so many IPs are involved here. You can in a small phone, Apple iPhone, there are trademark, there are patent, there are lots of trademark, lots of patent, lots of copyright, and design protection is there. And one IP is also here, trade secret, which is not governed by any law as of now in India. Okay, now first of all, we will discuss about what is trademark. Trademark is anything which which identifies a brand to a common consumer. It should be capable of distinguish the goods and services of one person from whom those of others, and may include shape, goods, packaging, and combination of colors. Of course, like if you are having the uh, burger from McDonald's, okay, and someone is having the McDonald's from Burger King, of course we can differentiate it any point of time. Okay, so like if like from a McD's you are having a burger of 50 rupees or 100 rupees. Okay, like branding is what you are ready to pay the much more amount for that brand, but on the street food, if I say if we buy street food, local burger from the street, okay, we are not ready to pay them uh, much amount, okay, but and we are ready to pay Burger King, McDonald's, and pizzas because of the branding. Okay, these are some of the examples of trademark. Mark include device. Device means where you can mention your logo. Just like you can say Adidas is a device because here is a logo and Adidas both we are mentioning brand. ICSI, CA, they are the brands. Heading, label, tickets. Some of gaming tickets are also can be registered as a trademark. Name, Amitabh Bachchan. This is a registered trademark. Signatures, word, letter, numeral, shape of goods, packaging, and combination of colors, and any combination thereof. Okay, and there are certain trademarks also coming in the scenarios nowadays, like sound mark is there, smell marks are there. Smell, you can register your smell as a trademark. Okay, so here are some options you can choose from them. Word, you can register a word as a trademark. Here we given the example of Google. You can choose numbers like 555. 555 is a trademark. Okay, device mark. The Amul girl, she's a device, and no one can use it except Amul. Okay, then packaging. The blue color packet. dairy milk pouring on the upside down, uh, Cadbury and chocolate. No one can use, even if the with the different name. Okay, if I start producing Mary milk chocolate, okay, or Neha milk chocolate, I cannot use this kind of packaging, even though my name is different. Okay, these are the product mark. Earlier days, before trademark act 90s, there were only product mark. Okay, so whatever names registered as a trademark on product only be registered uh, with the trademark authorities. Service marks register nahi hote the, but nowadays we can also register service marks. Okay, so product mark are जो कि product के ऊपर होते हैं, and service marks which are given by the service sector. Okay, we can register shape of goods also. Okay, so as a trade dress, but uska aesthetic look or outer look can be registered in a design act also, but the shape or trade dress in a logo form can be registered as a trademark. Then pattern also can be registered as a trademark. Then trademark, sorry. Then collective mark, as the name suggests, these marks are linked with a group of people, not with a single person. It can be owned by organization or institute, just like ICSI or CA Institute. They can file a trademark, their trademark as a collective trademark. Okay, then again, certification trademark, just like ICA, ISI, and EGMARK, they are the certification mark. And when someone is producing their goods with some standards, they can apply ISI mark as a certification mark over their goods. Okay, then one is sound mark. As I told you, if our sound is very different, we can register this as a trademark. Okay, this is the Britannia. If you have heard, this is a Britannia tone. Like we have, like we have, we can feel the sound on advertisement and all. Okay, and then color combination, the Coca-Cola color, red and white color. We cannot use this color in beverage sector in any of the, like if you are selling Pepsi with the red and white color, no, you cannot sell because color combination is already registered for beverages sector. Cannot use, you cannot sell water bottle or cold drink in a white and red combination, packaging combination. Okay, then the trademark can be designated by the following symbols, TM and R. What is the difference between TM and R in circle? When we apply any trademark, okay, then we can affix TM over our trademark, whatever we have filed, where we can mention it, our invoices, our advertisements, our boards. We can mention our packaging material. We can mention our logo, like just like Starbucks a logo is mentioned, TM. We can mention that way only. Okay, and when our trademark is registered, okay, then we can apply R in circle. Okay, here are some marks which are non-registrable trademark. Okay, mark resembling existing and established trademark. Of course, we should not file those kind of trademark which are already existing and established and confusing and deceptive mark. Some of like people, what they do, like if MACD, they want to file MACD, then वो M को छोड़ा छोटा बड़ा करेंगे, like, so these are the confusing mark. Okay, and these marks are non-registrable. If they file and if anybody file these kind of trademark, after some period of time, these trademarks are abandoned. Okay, descriptive trademark, just like coffee shop or coffee bars. Okay, you cannot sell water with the name of water. You cannot sell milk with the milk. Of course, you need to add Bisleri, okay, with water, or Amul with milk. Okay, so descriptive mark are not allowed because these kind of words, these kind of trademark create confusion between the laymen. Okay, if everybody will write water for the drinking water, then how will a layman can differentiate who are the manufacturer of this water and who are the manufacturer of that water? Okay, so descriptive trademarks are not allowed. Unlawful and prohibited marks. Prohibited marks, there is a list of some prohibited marks which is available on the government site. Anyone before filing those trademark can see it. And scandalous, obscene, and religiously inflammatory mark. Of course, these marks are also not allowed. Then again, laudatory and superlative words, okay, such as perfect, premium, these words are also not allowed. Then what are registrable trademark? Non-registrable trademark again, marks which have direct reference to the quality and character are not allowed. Just like cool for beverages and easy cook for cooking. Okay, there is a list of prohibited marks. Some of the marks I have mentioned, just like Guru Nanak, Lord Buddha, Mahatma Gandhi, UNO, WHO, WIPO, these are the under prohibited trademarks. No one can use it. There's a list of prohibited marks, and by this link, you can get the access of this list of prohibited trademarks. Then good trademark guidelines. Of course, when our client come to us and they wish us here to file a trademark, what kind of word should we suggest them? We should suggest them any coined word, invented word, okay, which have no reference with the direct character quality of the goods. Okay, just like Canon. Canon, into the printers, like they don't have any connection with the particular goods. Okay, if these are not invented or direct relation होगा तो like of course in future like बहुत सारे प्लेयर्स खड़े हो जाएंगे मार्केट में एंड मार्क जो है इतनी मेहनत करने के बाद भी इतनी इन्वेस्टमेंट करने के बाद भी एवरीथिंग विल बी जीरो. Okay, because common words can be used by the industry, by anyone. Okay, then adopt any arbitrary word, whether a dictionary word or not, which has no reference to the character or a quality or a service. Like these are the dictionary words, these are available in the dictionary, but they are not directly related to that particular goods. Just like Apple for computers, they doesn't have any connection. Apple is a fruit and computers are electronic product. Okay, these are not directly associated with each other. Okay, then we can file these kind of words also. Okay, then adopt a distinctive and fanciful trademark. Okay, again जिनका कोई करेक्टर या क्वालिटी अपने गुड से मैच ना होता हो ना सर्विस से मैच होता हो. Again, any name including personal name or surname of the applicant or a predecessor in business or a signature of a person who is not usual for the trade to adopt as a mark. Again, like you can say Agrawal for sweet shops. These are the very common, but you cannot have the trademark over it because it's a surname which everyone is using for a sweet shop. Agrawal Corner, Agrawal Sweet Corner. So you cannot take a trademark on it. Okay, and if you will file a trademark application for it, uh, you will not get the chance of registration. The money will be waste, the time will be waste. But if you have the name like Amitabh Bachchan, of course you will get the registration because this name is not in journal and surname is also not so journal. And if you think you are like you have the goodwill with this name, you can file that particular name. Okay, then we come to the well-known trademark. It means a mark which has become known to the substantial segment of public which uses such goods or services that the use of such mark in relation to other goods or services would likely to be taken as indicating a connection. Of course, well-known marks are those marks just like Apple. Okay, and well-known mark if they are registered in one class. Okay, and other person is using that particular trademark in other classes, then we will think that the earlier one has the connection with the second one. For let's take an example here. If if Apple is if Apple is for gadgets and mobile phones, and if I open a garment shop with the name of Apple and use their logo, of course, people will think that she has some connections. She have taken some license. She have taken some assignments from the Apple. Okay, and I will get the like what I they will feel there is a connection between both of us. Okay, and I will be what will get the advantage which should not which is not mine. Okay, like then these are the well known marks जो कि like अगर हम किसी और भी क्लास में फाइल करेंगे तो like we will get the like cognition, which is not good. Okay, like what are the major benefits of well-known trademarks? Okay, then well-known marks are better than registered mark. If here we take an example of trademark Puja. Puja is registered in class 3. Okay, for cosmetics. It is registered in class 3 for cosmetics. And can we register Puja in garments in class 25? Of course, we can file it. Why? Because Puja is not a well-known name. I will not use their goodwill if I file it in class 25. But if I use Apple in garments, of course, I will use the goodwill of Apple. Okay, people will like think I have any connection with the Apple trademark. Okay, that is not good because I cannot. I'm not able to uh, produce that kind of quality which Apple is supposed to manufacture. Okay, then well-known trademarks are protected across all classes of goods and services, even though the said well-known marks are not used all classes. Of course, uh, देन जब ये बहुत ज्यादा होने लग गया कि लाइक एक क्लास में जब वेल नोन ट्रेडमार्क होता था और लोग और अलग अलग क्लासेस में वेल नोन ट्रेडमार्क फाइल करना लग जाते थे एंड यूज करते थे उनकी गुडविल देन कोर्ट्स डिसाइडेड दैट वेल नोन ट्रेडमार्क विल गेट द एक्स्ट्रा प्रोटेक्शन and no one can file these well-known marks in any of the class, even if the well-known trademarks are not in that particular class. Just say Apple, they are not into garments, but I cannot use that Apple trademark in garments. I cannot use Samsung for manufacturing chairs. Okay, so these are the benefits of being well-known trademark. Okay, then there are here is some list of well-known trademarks. Bajaj, Bata, Bisdari, Whirlpool, Honda, KitKat, and Pizza Hut. These are the trademark you cannot use in any of the class, even if they are not manufacturing other goods. Okay, advantage of trademark. Prior applicant to trademark registry is the owner in most of the cases. Why I'm mentioning here most of the cases? Because later on we will see that every time prior applicant is not the prior owner. Okay, but of course, in most of the cases, prior applicant are the prior owners. Okay, it gives a exclusive right to the owner. Yes, if we file trademark and we get the registration, of course, we will have the exclusive right. And if someone wants to manufacture or reproduce my goods, they have to take a license from me. Okay, they have to take a franchisee from me. MACD is running in all over the countries by giving the license and franchisees. Okay, so they are expanding their business through their trademark. Okay, it indicates the source of origin of goods and service. Of course, when we apply a trademark on our product, we show them that we are from that particular. We are selling and sending these kind of product and services. Okay, it assure consumer of quality of goods associated with the marks. Of course, if that I told you earlier, a roadside पटरी का आइटम एंड आपका जो ब्रांडेड प्रोडक्ट है तो दिस इज द मतलब लाइक वी आर रेडी टू पे द ब्रांड एन नंबर ऑफ अमाउंट ओके it creates business goodwill and brand awareness. Of course, when we apply a trademark, people recognize us and it creates brand value. It advertise the product as well as distinguish from the other products. When we apply a trademark, people recognize us with the brand. It creates an intangible asset. Of course, when your trademark is registered, it's an asset. It's an intangible asset for the organization. It is seen as a primary evidence of legal ownership. Yes. Then trademark classification, goods and services. If I say there are when client come to us and they wish to file a trademark, what is the main thing we have to do? What kind of goods and services they are providing? Okay, then you should classify what are the classes are applicable for the particular goods or service. Sometimes it's one class or sometimes it's more than one or two classes. Let's say for take an example of garments, if your client into garments, then garment unstitched garment come into class 24 and stitched garment come into class 25. Okay, then we have to keep it in mind that what kind of goods and services client is dealing in. Okay, because once we have filed the trademark, then we cannot change the class. We can change the address, we can change anything, but we cannot change the class. Okay, so like there are 1 to 45 classes. Class 1 to 34 is for goods. Okay, government has classified n number of goods, n number of item in these 1 to 34 classes. Okay, and for class 36 to 45, there are service classes. Okay, and for online e-commerce, online selling purchase, and retailer and wholesaling, online, offline, and for shop registration and shop names, class 35 is there. Okay, then when you okay with the class, then you can file a trademark with the proper authorities. Okay, these are these classes, goods and services, called a nice classification. Okay, then priority in adoption prevail over priority in registration. Yes, that means even if your mark is you have filed the trademark, okay, and uh, you have searched that no one has filed a trademark, the mark is clear. Let's take an example of Puja in class 25 for garments. If it is clear and I have filed a trademark for class 25, okay, and after 6 months, someone filed a trademark, okay, with 50 years of user, okay, that they are using it since 50 years. For 50 years they are using it. Then of course, priority in adoption, that means the later one, okay, will get this trademark, not me, even though I have applied it first, but still I will not get the registration. These are the priority in, this is the priority in adoption prevails over priority in registration. Take an example, like uh, like if I file a trademark, if I file a trademark with the proposed to be used basis, okay, that I will मैंने सोचा कि ठीक है, after 6 months मैं एक business start करूंगी, but let's file it today. Let's file the trademark on proposed to be used basis. Okay, and someone file it after me. Of course, as I told you कि like वो वही बंदा जो जिसका user है. So please keep this thing in mind. If your client come to you and they should ask them, are you using it quite long or not? Do you have any user? Because nowadays what is happening when we file trademark application, the way we file trademark application is is quite problematic, because we generally we never ask client, are you using it or not. ऑलरेडी अगर क्लाइंट आपका यूज कर रहा है तो प्लीज लाइक वी शुड फाइल द यूजर एविडेंस एंड यूजर एफिडेविट. Okay, and like because if you file proposed to be use application is file करना बहुत easy है proposed to be use की, but like in future when the objection will come, okay, then opposition will come, then how will you like contest your trademark? Okay, so before filing it, ask your client, is there any user? If there is a user, then we should file the user evidences along with affidavit. Okay, then registration of mark is not a prerequisite in order to sustain the civil and criminal action against violation of a trademark in India. Yes, if you are not like if your forefathers are using some brand, okay, and they are selling it and they are not aware what is the trademark because it's more legal, okay, then what what are the implications? And your generation know what is the trademark, and you go to the like you came to know that someone has filed your trademark or it is registered, then what? Then you have the civil remedies and criminal remedies, and registration of mark. आपने अप्लाई किया है या नहीं किया है, you have the registration, no one can stop you. to go into the court. You can go to the court and take a action against the infringer. Even if you are a, you don't, you, आपने फाइल किया है, ओके, नहीं किया है तो भी ओके, यू कैन गो टू द कोर्ट इवन इफ इट इज रजिस्टर्ड, बहुत बढ़िया, नहीं है रजिस्टर्ड तो भी कोई दिक्कत नहीं है, यू कैन गो टू द कोर्ट विद ऑल द एविडेंस. Okay, then is an Indian trademark valid abroad? Okay, then of course the answer is no. Indian trademark is not valid abroad. Indian trademark, if it registered, are the territorial right only, and if you are expanding your business in abroad, you have to file a trademark in abroad. You have to file a trademark in that particular country. Okay, then of course certain country do recognize the Indian registration on the basis of you can get the faster registration, just like Nepal. If you are expanding your businesses in Nepal and you want to get the speedy registration in Nepal, then if you are registered in India, okay, while submitting your application in Nepal, you can also send your Indian registration certificate, and you will get the registration so soon because they consider your registration. But you have to keep it in mind that you have to file a fresh application. Indian application is valid in India only. Okay, foreign trademark registration. Indian trademark registration only covers India. That does it does not therefore afford protection in any other country. Okay, yes, separate application must be filed in each of these countries. If it is registered, protection is required. Like why I'm writing here separate application, we can file a single application also. You have heard about that single application for all over the world by the WIPO website. You can go and file a single application. But what is the problem in that application? Let's say, take an example, you are filing a trademark in 10 countries. Okay. And by the single application. Okay. And there is no problem, there is no objection in 9 countries. Okay. And one country has some objection, and you are into the process of clarifying those objection. Okay. Then what about that 9 countries? You will not get the certificate from that 9 countries. Till then, you will clearing out the objection from the 10th country. Okay, so keep it in mind that you will get the registration certificate only after all the 10 countries are okay with your trademark filing. Okay, if any of the country have objection, your trademark application will be pending with the all 10 countries. Okay, so it is my suggestion only that if you are filing a trademark in abroad, we have to hire a attorney there, okay, and file application there. Okay, वैसे भी अगर मान लीजिए आपने वाइको के थ्रू एप्लीकेशन फाइल कर भी दी, at the time of prosecution, you have to hire a professional there in that particular country. Then it's better to file a separate application. Application for registration in foreign country can be based on Indian application, of course. Like if you have filed in Indian application, it is registered, you can claim the user by the convention priority that may be claimed within the 6 months. If you have filed a trademark in India, and if you are filing trademark in abroad, okay, then you can claim the whatever user you have mentioned in the Indian application. Okay, then duration of a trademark registration. Once the trademark is registered, it is valid for the 10 years. Okay. And what after 10 years? You can renew it, and you can renew it in every 10 years. This is the only IP which can be uh, renewed n number of times. Okay, and there is no problem. आप फाइल करो, आपकी साथ पूछते हैं आगे कि वो ट्रेडमार्क यूज कर सकते. Okay, this is how we can search our trademark. Here, it's government की website, but this is the page where we can search. In search column, we can type a trademark which we need to file, and in class we can type a class, and you will get the search report, and where we can see that our mark is clear or not. If it is not clear, I will say don't file that kind of word. Okay. Otherwise, if it is journal word, then you should affix any suffix or prefix of something a creative word. Okay. Then otherwise, we should not file any journal word. Okay. Then this is the flow chart for registration of trademark. Have to conduct a search. Is this trademark available or not available? Once we file the trademark with the trademark authorities, then this after the stipulated time, which is as per the 1 month, but unofficially it can be 1 month, 1 year, or it can be more than 1 year. Okay. Otherwise, आपका जो trademark है, that will show the terminology formalities check pass or send Vienna codification. Formalities check pass means whatever application you have filed is okay. There is no discrepancy. And send to Vienna codification means that like whatever logo you have filed, that is gone for the codification. Your application is okay and went for some codification. Both status are okay. The problem is in formalities check fail. That means you have done something wrong. Okay, and you have to clarify it. Like within 1 month of the status of formalities check fail, you have to change. You have to send your reply within 1 month. Otherwise, your mark will be abandoned. Okay, so keep this thing in mind. And whenever the objection, whenever the examination done by the trademark registry, you will get either the FER, first examination report, or otherwise your trademark will be directed accepted by the trademark department. If it is accepted, then very good. Your trademark will be advertised in the trademark journal, which is available on every Monday on the trademark site. Okay. And if it is not accepted, they will mark for your trademark for hearing. Okay. Then again, it will take 1 year, 1.5 years, maybe 2 years. Okay. When hearing will come. Okay. Then after, when hearing will come, then you have to satisfy hearing officer. Nowadays, all hearings are virtual. Okay, you don't need to go to any trademark office. Otherwise, sometime before COVID, we have to go to the respective trademark registries for attending hearing with the long queue. But nowadays, all hearings are virtual thanks to the COVID. And if like your trademark, you are satisfying trademark officer, whatever objections they have made, that objection can be as per class section 9, as per section 11. Section 9 says your trademark is absolutely not registrable. Okay, just like I have mentioned that You have filed water for for beverages and drinking water. Okay, when your products are drinking water, you cannot file water as a trademark, and when your product is milk, you cannot file milk as a trademark. Okay, these are the absolute ground of refusal. Okay, so and then you should not file these kind of trademark. And section 11 says that your mark is registrable, but your mark is similar or identical with the already earlier trademark. Okay, it can be registered or unregistered trademark, but it is similar. Then show me why why they should not refuse your trademark. Then you have to satisfy them, like if you have filed the same trademark, you can say that these are for different goods and services. Okay, for let's take an example here, like if like some people are selling hosiery items for in garments, and other person is selling kids wear. Okay, you can differentiate, you can tell what is the differentiation in the goods. Okay, and you will get the mark. Okay, but you have to satisfy the registrar. So only after their satisfaction you will get the trademark registered in your name. Okay, again they will accept it, and it will be advertised in a journal. And if it is accepted in the trademark journal, advertised in a trademark journal, and within 4 months of time period, if it is lapsed, okay, with no problem, then if it will be registered in your name, it will be registered in the applicant name. And if it is opposed, okay, 4 months time period is the opposition period, generally called. If it is if opposition come, then applicant need to reply it in a counter statement. For both of the forms, they are TMO. Okay, like if you are not replying within a stipulated time of 2 months, there is no extension of from by like if you are not filing counter reply within 2 months, and 22 months are lapsed, there is no extension, and immediately your trademark will be expired. Okay, then if you have filed the reply, then again the opponent will file the evidence in support of opposition. Then by submitting that why your trademark should not be registered. Okay, then again within 2 months of receiving the evidences as per rule 45, you have to uh, send your evidences by way of rule 46. Okay, then again, a registrar of trademark will call both the parties for the hearing with all the opposition proceedings. After the opposition proceeding, if uh, they are satisfied that a position is wrong, then it will be registered in your name, and it will be registered and valid for 10 years. And keep it in mind, after 10 years, you have to renew it. Okay. Then these are the jurisdiction which right now I don't think have any use. In earlier days, like uh, it was so useful because we have to write the jurisdiction like in every form. Okay, nowadays also we have to mention that for what jurisdiction we are filing the trademark. But frankly speaking, because everything is online, everything will be come automatically, whether you're according to your client address, the jurisdiction will come automatically. Okay, otherwise there are five jurisdiction: Mumbai, Ahmedabad, Kolkata, New Delhi, and Chennai. Then forms and fee structure. Okay, then when client come to you and ask, they wish to file a trademark application, then like just like a GST application, okay, you can file their trademark application also with their DSC, okay, in form TMA, and for individual and for single firm, okay, who is 4500, and for any other cases, whether it is company or a partnership firm or a society or a trust or whatever, like the fees is 9,000. Okay, but in case your client has startup certificate or MSME certificate, sorry, yes, startup certificate and MSME certificate, then the government fees will be 4,500. That means they will get the discount of 50%. Of course, when you are filing trademark application, you will get the other work also. So filing of trademark registration is very fruitful for FDCA. Okay, then of course you have to do MSME compliance and startup compliance, and you can get the good amount from the client. Okay, then what? And filing of TMA application is very easy. It's not complicated, just like filing like ये आपका जो टैक्स फाइलिंग जीएसटी फाइलिंग इससे फार इजी है टीएमए फाइलिंग एंड देन फॉर्म टीएमएम फॉर एनी अमेंडमेंट लाइक your client they have shifted from Gurgaon to Noida, okay, and they are saying sir हमारा address change करा दीजिए, then you can file TMM and it will be done by only 900 rupees as a government fees, okay. And what, after 10 years of registration of trademark, you can file TMR, and the fees is 9,000, and you can renew your client's trademark uh, very soon. Okay. And TMC, of course. TMC, we will discuss this later also in other slides with copyright. When you're filing artistic work as a copyright, then you have to take a NOC from the trademark department. Okay. Because like just I've shown you Eddie Bond, okay, with the artwork, and where the artwork and words are together, okay, and you are filing trademark and copyright application all together, okay, then like for filing copyright application, before filing copyright application, you have to file TMC before the trademark registry for taking NOC. Okay, then TMO that I told you earlier, for any opposition and counter statement, you have to file opposition and counter statement, sorry, TMO, and with the fees 2,700, and form TMP, that is for the assignment. Okay, when you are commercialize your IP, when you are commercializing your IP, when you are selling your IP, okay, the fees is 9,000, and you have to do certain compliance like immovable property. You like you people like draft deeds and affidavit, certain deeds and affidavit, and pay the stamp duty. You have to do all the compliances here, and after that, the trademark will be assigned to the new owner. Okay, then TMU for the license, like जैसे मैकडी है, मैकडी अपना लाइसेंस जितने भी आगे यूजर्स को देता है, like they have to file TMU with the trademark department, and the fees is 4,500 for the registered trademark. TMG, when you are registering yourself as a trademark agent, you can file TMG for 2,500, 4,500, and of course, you will be you can work as a trademark agent. Okay. In case of in case of physical filing, okay, you will not get the discount of for 10%. जो फीसेस हैं ये सब, इनमें सब 10% ऐड हो जाएगा. जो आपकी 4500 की फीस है फॉर फाइलिंग टीए में 5000 हो जाएगी, और इन अदर केसेस इट विल बी 10,000. ओके, तो ऑनलाइन काम करेंगे हम तो वी विल गेट द डिस्काउंट ऑफ 10% फॉर एवरी एप्लीकेशन एंड फॉर्म. Okay, then trademark part is over. Now we are coming to the industrial design. You can say design patent, you can design registration, anything you can say. Okay, so what is design? First of all, what is design? आप आप सबके हाथ में फोन है. फोन का जो आउटर लुक है, the aesthetic look, the outer look will be registered, can be registered as a design. Okay, as per the design. Okay, so for what are the features like of any product, the outer look, shape, configuration, pattern, that can be registered as a design. Okay, that is the chair. That is not a normal chair. The design of the chair is very different. Okay, and if like it's commercially, the manufacturer is able to sell it commercially, okay, then it can be registered as a design registration. I have given the example of classic Vespa scooter and Apple iPhone. Okay, so जैसे I have told you earlier, I have like you all seen in my slide that Apple phone have many IP. तो जो आपका लोगो है कटा हुआ सेब, और एप्पल आईफोन, that is registered as a trademark, and the design, the outlook of that phone, that will be registered, that is registered as a design or a design registration. Okay, and you know, Samsung paid the empty penalty for using Apple style, Apple Outlook for their phone. Okay, so like it's not easy to use anybody's design. Okay, the heavy fees, heavy penalty will be imposed. Any guesses? Who am I? Any answers? Okay, so मुझे पता है कि like everybody knows that this is the Coca-Cola bottle. Okay, so without any label, we can analyze, we can guess it is a Coca-Cola bottle, and anybody can easily find out ये क्या है. So like whatever the design is there, whatever the outlook of this bottle, that will be registered under the patent act. Sorry, design patent. Okay. The Apple has very different and worldwide famous design as iPhone. It is capable to distinguish its product than other. Of course, the design of the Apple phone, it's the different design, distinguished design, and registered under design registration. Okay, for design registration, okay, what are the like checklists you have to fulfill? It should be new and original and not previously published. Okay, so no, previously published means the day when you have filed the design application. On the day you are filing design application, it should not be anywhere, not commercially used. No commercial use, no pictures, no Instagram picture, no Facebook picture, no, not on Google. अगर ये available है before the design application, you will not get any registration. That is for sure. Because मेरी first application के साथ यही हुआ था. This is my personal experience. When I filed the first design application in 2014. Okay, and I was not aware, and it was not in my mind. Of course, हम सबने पढ़ा होता है, but it was not in my mind that client should not like कहीं पे यूज ना हो उसका, बट वो ऑलरेडी यूज थी, कमर्शियल यूज कर रहा था क्लाइंट. एंड आफ्टर दैट आई हैव फाइल्ड द डिजाइन एप्लीकेशन, एंड FER आया वहां से डिजाइन डिपार्टमेंट से, एंड देन आई गॉट टू नो दैट आई कैन नॉट गेट दिस डिजाइन रजिस्ट्रेशन बिकॉज इट इज ऑलरेडी पब्लिकली अवेलेबल. ओके, सो लाइक आपका खुद का क्लाइंट भी उसको यूज नहीं कर सकता. ओके, देन आप आज फाइल कीजिए ट्रेड डिजाइन एप्लीकेशन, एंड यू कैन स्टार्ट यूजिंग इट फ्रॉम टुमारो. डोंट वेट फॉर द registration certificate. Okay, the design should relate to feature, shape, configuration, pattern, composition. Okay, so you can get the filing done. Okay, design should not include any trademark or copyright. Of course, trademark में जाएगा, copyright में जाएगा, and design में जाएगा. And one thing very important for the design registration, like it should be finished article. It should be a finished article, not should be in an open state. Let's take an example of almirah. Okay, you cannot show that open the almirah, the inside cabinets and inside drawers are my design. No, these are not registrable. Okay, if it is closed, then only closed state can be registered as a design. Okay, then again, items that cannot be registered as a design under design act: signs and emblems, flag of the country, size of any article if it is changed, structures and buildings, integrated circuit, layout design. We have the different law for that. Books, calendars, certificates, trade variation, workshop, nothing. These are not registrable. Okay, who is entitled to seek design registration? Okay, like who is the owner, who is the author of the design, who made it? Okay, and if it is unpublished, original, no one can stop you for getting the registration. Okay, then acquire jo like what like if I have the organization and I have designed something from my employee. Okay, then I will be the owner because I have paid him or her the valid consideration. Okay, and in market also you can get if you are paying someone any consideration, even if they are not your employees. Okay, valid consideration means this design can be yours. Okay, and if it is like you have paid the consideration, you can be the owner of that particular. Okay, in case of more than one author, the design can be applied by the joint authors. Okay, now the patent. A patent is an exclusive right. Yes, it is an exclusive right for invention, for granted invention. What are the invention? What is the biggest example of invention? Nokia to smartphone. When हम सबके हाथ में नोकिया हुआ करता था और सडनली स्मार्टफोन आया था, तो दिस इज कॉल्ड द इन्वेंशन. ठीक है, फॉर दीज काइंड ऑफ इन्वेंशन, what is the IP here? The IP is patent. Okay, just like Apple phone, we have seen the trademark, we have seen the design, now we are seeing the patent. In other words, patent is an exclusive right. Of course, like no one except Apple can produce that kind of product. Okay, if anybody product if anyone produce that kind of product, then of course Apple will sue, and like they have to face the implications. Okay, To get the patent, technical information about the invention must be disclosed, of course. Like when you say your product is invented product, it should have the inventive steps. Okay, इंडस्ट्रियल यूसेज होना चाहिए, इन्वेंटिव स्टेप्स होना चाहिए, समथिंग कुछ भी टेक्निकल होना चाहिए. इवन इफ लाइक फार्मा फार्मा इंडस्ट्री में है तो लाइक जो मेडिसिन ऑलरेडी बनी हुई है, लाइक आप उससे सिमिलर मेडिसिन बनाओगे, नो देर इज नो इन्वेंशन. बट हाँ, उसका अपग्रेडेड वर्जन आप बना रहे हो, दैट इज द लाइक patent. This is called the invention. Okay, like already exist fan hai, we are using fan since long, and we are using light since long. If we made a product कि एक फैन में ही when we switch the button, okay, then फैन प्लस लाइट दोनों एक ही इंस्ट्रूमेंट में साथ में स्टार्ट होंगे, then is it an invention? Is it an invention? No, it is not an invention. Why? Because already existing thing को आप दोनों को साथ में लेकर आए हो, that is not an invention. Invention is just like कि like you are you are not using the fan button, and you are operating your fan by the remote control. Okay, it's an invention, but you are, if you are coming together with the already existing thing, is not patentable. Okay, and patent is a monopoly right. When someone grant with the patent, okay, then they will enjoy the monopoly for 20 years. Okay, and after 20 years, it will be publicly available, and everyone can manufacture that kind of item. Okay, then you cannot stop after 20 years, but 20 years you can enjoy the monopoly. You can you can decide to whom you should give the license or to whom not. But if governments see that the product you have invented is beneficial for the human mankind, okay, then you have to give the permission to the government to manufacture it in humankind. Okay, so then like this is the mandatory, you have to give them right. Okay, then अच्छा, like 20 years के लिए grant तो हो गया, but you have to renew the patent every year. Okay, and you have to submit that you are using it. Like आपने invent किया सब कुछ, and you have done patent, you have done everything. ऐसा नहीं है कि उसको बस देखते ही रहना है, तो इंडस्ट्रियली आपको यूज भी करना है, तो you have to submit evidence. Then patent right. A patent owner has the right to decide who may or may not use the patented invention for the period in which the invented invention is protected. Of course, he is the owner and he will decide. Okay, and वो यूज कर सकता है, बना सकता है, डिस्ट्रीब्यूट कर सकता है, इंपोर्ट कर सकता है, सोल्व कर सकता है, विदाउट द नो वन कैन do these kind of things without the owner's consent. Okay, and patent owner give the permission to the license और sell भी कर सकता है. Patent owner है, वो नहीं बना रहा है product, वो sell कर सकता है. तो जो new owner होगा, he will be the patent owner. Okay, once the patent expire, वो publicly available है, everyone can commercially exploit it. A group of scientists invented a drug. Like if some pharma company has some scientists and they are inventing a new drug for the company, then patent will be in the name of that company, not with the scientist. Okay, because scientists getting the salary because they are the employee of that company. Okay, then they cannot get registration in their personal name. ओके, पेटेंट टाइप. पेटेंट के दो टाइप्स होते हैं, प्रोडक्ट पेटेंट एंड प्रोसेस पेटेंट. ओके, जस्ट if you have invented some chemical compound that we can touch it. Okay, that is the product, and we can have the product patent on it. And the way we have produced it, the process we have produced it, it's called the process patent. But in India, you cannot file process patent application. For that, you have to go to the US only, because India में process patent grant नहीं होता. Okay, and just we have all have our computers, laptops, mobile phones with us. In some products में there are so many patents are already involved. Hundred of patents, hundred of inventions are there. Okay, that is the 10 years old boy, Hrideshwar Singh Bhati, and he has created 6-player variants of chess, and earned a patent for his invention in 2012, and making him the youngest patent holder in India. So I must say, imagination is more important than the knowledge. We all have the knowledge, but if we don't have the imagination, then we are not using our knowledge properly. Okay, then even with the less knowledge, some people are so creative. Okay, so creative, the creation and imaginations much more important than knowledge. Then we have a trade secret. What is trade secret? It is a business information. जैसे तरला दलाल की recipe. Okay, अब now it is disclosed with everyone, but आज से कई साल पहले it was not disclosed. So recipes of every which are not disclosed, बस आपके सामने प्रस्तुत कर दिया जाता है वो आइटम, ठीक है, which is very confidential, that no one can use it. Just like Coca-Cola recipe, but 100 of years say we are having the same taste of Coca-Cola because of the recipe of that soft drink, and only few members, like some board of directors or the key managerial person, have know the recipe of that Coca-Cola. Okay, and these are called as trade secret. Okay, and there is no law. There is no law for the trade secret. If if anybody leak the recipe of that Coca-Cola or anybody's trade secret, okay, then you have to go to the civil court only. There is no other remedy. Okay, like आपकी recipe तो गई. Then GI, we have GI. A geographical indication is a sign used on a product that have a specific geographical origin and possess quality or a reputation. Up, let's take an example here. Can we cultivate Darjeeling tea in Noida? No, cannot cultivate, because Darjeeling tea cultivate करने के लिए जो origin, जो quality दार्जिलिंग में है वो और कहीं नहीं है. असम टी, ठीक है, आप कभी कोई आपको कहेंगे हम दिल्ली में ये नोएडा में हमने या दिल्ली में हमने ये कल्टीवेट किया है टी, कोई पिएगा? नो, आई डोंट थिंक कि नोबडी विल टेक इट. ओके, तो हर बंदा जो भी टी प्रोड्यूसर है वही यही बोलता है कि हम असम के बगानों से या दार्जिलिंग से लाए हैं. तो व्हाई दे आर यूजिंग इट? बिकॉज that geographical origin possess that quality, and only the producers who are producing in that particular geographical origin, they can only affix that sign over their product. Like मैं अगर अपनी एरिया में कल्टीवेट करना शुरू कर दूं चाय, I cannot mention I'm selling the Darjeeling tea because this is not the Darjeeling tea. Okay, अगर मैं दिल्ली में बनारसी साड़ी मैन्युफैक्चरिंग कर रही हूँ, ठीक है, although it's a silk sari, but it is not a Banarsi sari. Okay, so like for these kind of GI tag, I should have uh, particular geographical origin, and I should have possess some qualities and reputation for that particular area. Some examples are Darjeeling tea, Mysore silk, Rasgulla, Bengali Rasgulla. These are some of the examples. Here are some more examples also: Nagpur orange, Kashmir Pashmina, Tirupati Laddu, Darjeeling tea. Okay, who can apply for GI? Any association of person or a producers or organization and authorities. Okay, जो कि like अपनी एरिया के इंटरेस्ट के लिए, प्रोड्यूसर्स के इंटरेस्ट के लिए काम कर रही है, they can apply for the GI for the as a whole, not for a single person, for area, for that particular origin. Okay. Then we come to our topic, copyright. It is an exclusive legal right to reproduce an original work of authorship fixed in any tangible medium of expression, to prepare derivative work based on original and perform display the work. Of course, the work should be for what we are taking copyright. The owner will be the have the right to reproduce it, to reproduce its original work or in any other form, like um, Harry Potter movies. Like once the author of the Harry Potter started like writing some books on it. Okay, then she started with some of the producers. She started playing movies of Harry Potter, and then thereafter she translated in many other languages. Okay, so she is the only person, okay, who have the right to produce or reproduce it in any medium, in any form, like literary form or cinematography, film or anything. She has the only right. Okay, like we have different classes of copyright work, literary work, just like आपकी books. हमने जो CA में, CS में सब ये books हम पढ़े हैं, like all these are copyright protected. Some of them are copyright protected, and copyright में एक चीज और मैं कहूंगी, copyright is the like IP. When you create it, you can write C over your work, even if you have not filed that copyright application with the trademark department. Okay, you just create it and write C. That means you are copyright protected. There is no need to go to the for filing a copyright application, but it is always recommendatory, because if anybody is infringing your right, okay, there should be some documents that prove you are the actual owner. Okay, because court always see document first. Okay, and if you don't have the registration document with you, then court will take time, that they will assess that you are an actual owner or not. If they will assess, they will take time for it. But if you have the certificate, no need to take such time. Okay, literary and dramatic work or theater artist, they cover in that dramatic work and artistic work. MF Hussain जो भी पेंटिंग्स बनाते हैं, दैट लाइक सब कॉपीराइट होता है. सिनेमेटोग्राफी वर्क, अगेन पूरा बॉलीवुड cinematography, every movie, serials that come into that area. Sound recording work, sound recording again, आपके songs, audio recording, everything related to sound come into it. Then आपका music work, then musical notes, musical composition come into that, and computer software work. If you have designed any app just like Ola, Uber, Oyo, okay, then you can file a copyright application for your app and software work. This is the official site of copyright. Here you can see the filing of application, and CS also can file the trade copyright application by the applicant himself. Okay, because applicant himself file this application, then CS on their behalf can also file. Okay, so there is no problem, and the application filing is so simple. You need to add just applicant personal detail. If it is a company, then you need to mention company name, address. Other is the like copyright already published or not, क्योंकि copyright में ऐसा कोई दिक्कत नहीं है कि if unpublished होगा तो ही वो फाइल होगा. आपने मूवी पहले बना के मार्केट में दे दिया, मार्केट में आ चुकी है, देन आफ्टर दैट यू कैन फाइल कॉपीराइट एप्लीकेशन ऑल्सो. बुक है, बुक मार्केट में लॉन्च हो चुका है, यू कैन फाइल कॉपीराइट एप्लीकेशन दैट ऑल्सो, देन ऑल्सो. ओके, तो लाइक कोई प्रॉब्लम नहीं है. तो यहाँ पर पूछेगा आपसे कि पब्लिश्ड है कि अनपब्लिश्ड है. इफ इट इज अनपब्लिश्ड, अनपब्लिश्ड, पब्लिश तो पब्लिश. ओके, देन आपसे पूछेगा कि इज द ओनर इज द ऑथर. Okay, then owner and author can be two different person. Okay, or it can be one person also. Okay, agar owner and author the two different person hai, then you have to take a NOC from the author. Okay, these all are the due diligence we have to do as a professional. Even me or a CS or a CA are filing this kind of trademark, so we all have to file whether a trademark application or a design application or a copyright application, whatever is the application. It is just like GST के लिए आप क्लाइंट से DSC आपके पास होता ही है, और आजकल तो DSC बहुत एक्सपेंसिव भी नहीं है क्लाइंट्स के. You can file that application with the government authorities, and you have to upload a work, you have to upload client signature, and you can file the application. Okay, and after filing the application, you may or may not receive any objection. If objection is not received, then it is just like the trademark. Okay, so like it depends what application you have filed, what kind of application you have filed. If some kind of copyright take some time, just like cinematography and all. Okay, so like it takes some time, but application filing, it's very easy task here. Okay, then these are the statutory fees. That is all available on the site. No problem. I have also cut and pasted here. Okay, so for literary work, if your client uh, like uh, have any book and they want the registration of the book, then like for commercial use, the fees is 2000, and for non-commercial use, fees is 500 only. And for dramatic work, again, for both commercial and non-commercial use, the fees is 500. And for musical work, musical notes, musical composition, the fees is 500, 500 again. And for the artistic work, for non-commercial use, it is 500, and for commercial use, it is 2000. And again, I've told you, for artistic work, you have to take a NOC from the trademark department, and the fees is 9000. So the total fees for the artistic work, that is 2000. Okay, so like if your client like in the field की वो कुछ प्रोडक्ट इस टाइप के बनाता है, जैसे just like cooker, he's in the like manufacturing of cookers, he's in the manufacturing of shoes and like these kind of items जिसमें big boxes include होते हैं, like for all these things we can file artistic work. Okay, then cinematography film for non-commercial use and commercial use, both the fees is fine. And for sound recording, if you have prepared a song, then the fees is 2000 and 2000 for both purposes. And if you are doing any changes in the literary and artistic work, the fees is 2200 for commercial and 1000 for non-commercial. And the list is here for all the changes you are doing. And what is not copyrighted, of course, जो भी हम ट्रेडमार्क करेंगे, पेटेंट करेंगे, डिजाइन करेंगे, course these are not registrable as a like आपने सिंपल टाइप किया कोई वर्ड एक पूजा, तो वो कॉपीराइट नहीं होगा, ठीक है। बट अपने पूजा के साथ कुछ आर्ट वर्क ऐड किया, कुछ लोगोस, कुछ सिंबल्स, कुछ फ्रेजेस, कुछ लाइक जैसे जस्ट लाइक नाइकी, नाइकी उसके साथ चेक का साइन प्लस में आपका आप जस्ट डू इट टैग लाइन, ओके। और मान लीजिए कोई और कोई लोगो है, जैसे एप्पल का लोगो है, तो ठीक है, तो देन यहाँ पर आपका आर्टिस्टिक वर्क होगा, तो आर्टिस्टिक वर्क में लाइक आप यू कैन फाइल कॉपीराइट। वर्क दैट हैव नॉट बीन फिक्स्ड इन अ tangible form of expression, yes, मतलब लाइक आपने बोला कि समथिंग इज कमिंग इन योर माइंड एंड यू हैव एनी आइडिया and you are unable to incorporate it in a tangible form, then you cannot get the copyright done. Okay, and simple formulas, simple methods, procedures, calendars, these are not registrable under Copyright Act. Okay, and some common chart measurement, calendars, heights and weight charts. Like if we take an example of dictionary. Okay, so like अगर आप डिक्शनरी उठाकर उसको कॉपीराइट कराना चाहते हैं तो वो तो ऑलरेडी कॉपीराइटेड होगी, बट अगर आप उसमें कुछ कंटेंट आपने ऐसा ऐड किया, आपने समथिंग कुछ न्यू वर्ड्स उसमें ऐड किए हैं, देन ऑफ कोर्स यू कैन गेट द कॉपीराइट ऑफ इट। जैसे कि अब लाइक कोई मूवी है तो मूवी तो भाई जिस बंदे का है प्रोड्यूसर है, हु इज द ओनर, बट जो 2 मिनट की क्लिपिंग है जहाँ पे अपने रिव्यूज दे रहे हैं आप एज अ यूट्यूबर, तो यू कैन हैव द कॉपीराइट फॉर दैट पर्टिकुलर 2 मिनट्स की वीडियो, ओके। देन ड्यूरेशन ऑफ इंटेलेक्चुअल प्रॉपर्टी राइट्स, देन आपका जो ट्रेडमार्क है दैट इज वैलिड फॉर 10 years एंड रिन्यूअल एन नंबर ऑफ टाइम। Okay, then आपका copyright that is valid for 60 years. 60 years of what? 60 years after the death of owner. यानी कि जो हमारे कॉपीराइट है वो ड्यूरिंग द ड्यूरेशन, जो लाइफ टाइम है, लाइफ टाइम तक चलते रहेंगे प्लस 60 years, ओके, आफ्टर द डेथ की डे से 60 years तक भी चलेंगे। पेटेंट है, पेटेंट 20 years तक आपके वैलिड है, 20 years के बाद देर इज नो रिन्यूअल, ओके। जो भी रिन्यूअल है वो 20 year में ही चलेगा, हर साल हर साल हर साल, बट 20 years के बाद एक सिंगल रिन्यूअल भी अलाउड नहीं है। देन डिजाइन इज वैलिड फॉर 10 years एंड यू कैन रिन्यू इट फॉर 5 years फॉर वन टाइम ओनली, यानी कि टोटल ड्यूरेशन दैट इज 15 years। Okay, these are the some example of smart infringements. All products are looking जैसे कि बिस्लरी की बॉटल है, तो लाइक when you are going to the roadside and you are feeling thirsty, and I don't think we will be like bothered about कि एक बार पढ़ लो, ठीक है, बिकॉज मुझे तो सब बिस्लरी ही लगेंगे उस टाइम पे when I will feel thirsty. So keep it in mind that These are the smart infringements. These are again like some of the आपका infringements के ही आपकी types हैं. Okay, then scope of professional, like of course, okay, qualification of trademark agent. We come to that, like it should be a citizen of India. Okay, then 21 साल से कम की एज नहीं होनी चाहिए and graduate होना चाहिए. And if it is a advocate, then okay. Otherwise, अगर CS है, then भी okay. और अगर like आपको ये वो citizen है, 21 year का है, graduate है, तो he has to pass some exam. Then I will say that professional opportunities for CA. I think he like we all understand that he by learning IP, we all can file trademark application and other applications also, trademark, copyright. And apart from that, apart from that, like valuation of intellectual property rights, CAs are the role of CA in intellectual property right. It's so important because, of course, IP is not just legal. Okay, they can do the valuation of intellectual property. Okay, CA assess the monetary value of IP assets like patent, trademark, copyright, design, and trade secrets. Okay, none other than CAs can handle this matter. Okay, efficiently. Of course, these valuation of IP, intellectual property, are important for when they are in जब कंपनियां इंडस्ट्रीज जो हैं मर्जर एक्विजिशंस करती हैं, फाइनेंशियल रिपोर्टिंग देना होता है अंडर IFRS. Okay, as per the accounting standards. And when like industries go for the licensing and royalty agreements, they have to do the valuation of IP. Okay, then IP accounting and financial reporting. Okay, then like proper accounting treatment of IP is required for balance sheet, amortization, and impairment. Okay, then ensure compliance with the Indian accounting standard and international standard. Okay, then CAs are the person who can help to maintain the IP portfolio management of the company because they have that caliber in them, they have that intelligence in them. They can manage the IPR portfolio. Like, let's take an example here. If there is a pharmaceutical company and CAs are you are there, and in journal, when a pharmaceutical company file their trademark, they file like चलो जी 500 ट्रेडमार्क फाइल कर दिए इकट्ठे एंड व्हाट दे आर प्रोड्यूसिंग ओनली 10 100 trademarks and 200 trademarks. What about the rest 300 trademarks? Okay, then in that kind of trademarks, you can if you can have a strategy with the board of directors and with the management, and if they are just like non-usage ke hain, then you can assign them and commercialize it. And if you think like uh, uh, industry or company can use it in future, then you can license it for some period, and that IP asset जो dormant पड़ी है, they can produce revenue out of it. Okay, then taxation, of course, taxation is very important. See advice on tax planning of IP, capital gains of IP transfer, royalties and licensing income, R&D and incentives, and IP related tax benefits. Then they can audit, IP audit and risk management. They can conduct IP audit. Okay, they are the best person for it. Verify ownership and rights. For let's take an example, IP file हुआ है 50 साल पहले, and the board of director, the shareholders were different that point of time. Okay, then and nowadays कंपनी का एड्रेस चेंज हुआ है या कंपनी का नाम चेंज हुआ है, लाइक they have to see the ownerships and rights, check legal compliance and contractual obligations are there, identify underutilized IP assets for revenue generation. Of course, that I told you कि जो भी dormant पड़ी है IP, you can use it for the revenue generation. Help protect business from IP litigation and financial loss. Then advisory and strategic planning. CAs can guide businesses on IP strategy, including licensing and commercialization. They can decide the cost benefit analysis of IP registration. They can do the portfolio management to increase company valuation. They can advise startup and MSMEs on monetizing IP efficiently. They can provide legal advisor. They can be a legal advisor and litigation support with the team. And next, role in dispute resolution. While not as a legal practitioner, CA can provide the financial evidence in IP litigation of the or dispute, just like royalty calculation, loss assessment due to infringement, IP valuation report for courts or tribunals. Okay, so at the end, I will say like CAs are the CA bridges the gap between the finance, taxation, and legal aspects of IP. Their expertise ensure IP assets are properly valued, accounted, and monetized, which aids strategic and financial value to the business. And at the end, I will say when you file a trademark of your client, you should do you should regular check IP watch. You should have the IP watch. Okay, once you have filed the trademarks of your clients, like nobody is using it for that. Like you have to weekly, you can search weekly that no one else have filed the trademark. Okay, because आजकल ब्रांड को बनाना इजी है बट उसको प्रोटेक्ट करना इट्स वेरी वेरी important. Okay, then intellectual property right protection, like just like it is just like your कि अपने घर को आपने बना लिया बट प्रोटेक्ट तो करना है. ऐसा तो नहीं है कि दरवाजे आप खुले छोड़ देंगे सो दैट कि anybody is trespassing your area. Then this is the problem कि like we have to take an action. हम ये नहीं कह सकते कि गवर्नमेंट विल टेक एन एक्शन कि 4500 का फीस गवर्नमेंट ने लिया तो है, बिकॉज जनरली क्लाइंट कम टू अस एंड से मैडम गवर्नमेंट ने फीस लिया है तो वो ही नोटिस भेजे. नो, अगर कोई आपके ट्रेडमार्क को इन्फ्रिंज कर रहा है, कोई ट्रेसपास कर रहा है, देन यू हैव टू आपके क्लाइंट को यू शुड गाइड, टेक सेंड लीगल नोटिस टू दैट पर्टिकुलर पर्सन. ओके, अगर आपका ट्रेडमार्क रजिस्टर्ड है, you can go to the high courts and you can get the stay order within I think 15 days or 20 days. You can get the stay order in your favor. Then you should do the internet searches, timely internet searches. Okay, and for that you can take good amount from your client. Okay, and you can tell your intern, tell your employees to have a search, or it's not that much complicated because nowadays everything is available on internet. Okay, so like if anybody is using your trademark, okay, you can do the trademark search also. Okay, for like in for ROC में name approval के लिए we have to do it already. So like it's not new for CAs also. So like searches are very like already we all know. So like you can have your article there and weekly check एक बनता है, ठीक है, and you can have the like good amount for your from your client. And for any other thing, for any other consultation, you can consult your counsel. Okay, thank you so much. I am done here, and you may ask any question. And if there is no any question, I can complete my 3 or 4 slides. Okay, then now we can go further with our slide. Role of IPR in business growth. Of course, if in, for intellectual property rights play a significant role in fostering business growth by protecting innovation, funding, franchising, encouraging investment, and enabling companies to leverage their intangible asset, encouraging investment and funding. Of course, if you are IPR protected, okay, then like funding and investment is no problem. IPR gives the investor confidence that आप long term ही जाओगे. Like everyone can is ready to invest in your project, in your business, if you are already protected under intellectual property right. Because why? Because it reduces the risk of copying or losing the value to competitors. Of course, then monetizing and licensing. Companies can generate revenue by licensing their intellectual property to other businesses. Of course, like आपने अपना brand खड़ा कर दिया, तो like सब already जब brand established है, तो market is ready to take a license from you. They are ready to give your services. They are ready to produce your product. Okay, so like यहाँ पे monetization, you can earn money by licensing. Okay, international expansion is very easy. If you have a strong IP, then there is no problem. You can start business in India and start export easily. Okay, and expand your business in any of the country, because it reduces the risk of their innovations being copied. But you have to take care in mind that if you are expanding your business abroad, first of all, file trademark or like patent these kind of IPs there also. Because if like इंडिया में प्रोटेक्ट करना इट्स नॉट सफिशिएंट. इंडिया में प्रोटेक्ट करेंगे तो सिर्फ इंडिया में ही आपको प्रोटेक्शन मिलेगी, इंडिया के बाहर आपको प्रोटेक्शन नहीं मिलेगी. Then role of IPR in business growth. Increased revenue through IP assets. Companies with a strong IPR portfolio often generate significant revenue from licensing deal. Of course, like आप कितने भी लोगों को n number of people को license दे सकते हैं. Like and everybody what आपको royalties and compensation they will pay. Boost in market value. Businesses with strong IPR protection typically have higher market valuation. अब एक बंदा जो अपना बिजनेस तो बना रहा है बट उसकी कोई आईपी ही नहीं है, कोई ब्रांड वैल्यू नहीं है, कोई ट्रेडमार्क नहीं फाइल किया है, कोई पैटेंट फाइल नहीं किया है, कोई कॉपीराइट नहीं फाइल किया है, तो लाइक कैसे अपना वो बिजनेस बूस्ट करेगा. The study shows that the firm with well-protected IP are more attractive to investors. Matlab, investors are ready to pay much more amount if you are IP protected, which can result a higher stock price. आप हाई स्टॉक प्राइस भी रख सकते हैं, कोई इसमें इशू नहीं है, बट अगर आईपी आपका मजबूत है तो ही ये पॉसिबल है. Competitive advantage: firm with patents enjoy monopoly right for 20 years and enabling them to control market share in their industry. Innovation and economic growth: economies with stronger IPR system show more innovation. According to OECD, business in IP intensive industry contribute about 38% of total GDP in the European Union. Okay, then job creation and economic impact. According to the study by US Chamber of Commerce, IP intensive industry support 45.5 million jobs in the US and pay workers 46% higher wages than non-IP intensive industry. But uh, you can say that India is okay. Then at the end, I would like to share one thing also. According to the International IP Index, I will like to tell India's state IP compliance status. India's rank is 42nd out of 55 countries and score 38.64%. That is same as in year 2022. There is no improvement. That you can say India is like a least compliant of IP. Okay, so we need good courts, good strong IP courts, faster dispute resolution, and better IP protection, and good professionals for like all these lagging. Because India is not a worst performer, but it remains in the lower tier of the global IP compliance. Now, if you have any questions, please let me know. Otherwise, any questions?
Yes, ma'am, we have few questions.
Yes, ma'am.
Um, the first question is by C. Abhimanyu Nanda. How can a practicing CA give services of registration of trademark, copyright, and other intellectual property rights? And how can practicing CA get clients of this work? Where and to whom a CA should contact to get the service to give the clients? What are the reasonable fees that should be charged from clients? Whether UDIN needs to be generated?
Uh, Begin like just like GST application. Okay, what we do by the by client DSC, you can file trademark application. Of course, you are not that or the you are not a practicing CA, sorry CS. because they can file the application by their DSC, but CAs can also file the same by the client DSC, just like GST application. Okay, by the name of the applicant himself, they can file application by by their login by creating their login ID. They can file trademark application or copyright application as a proprietor, not as an attorney. You don't need to take a power of attorney from your clients. Okay, and you can file copyright and trademark application as a client filing it itself, himself. Okay, then like what is the reasonable fees? You can say it depends on like the client to client. Okay, then like you have government fees is filing for trademark is 4,500. Okay, and 9,000 as the case me as I told you earlier. But like what will be the professional fees? Like it depends on you and your clients, obviously. So like I should not comment on it. These are the like any reasonable fees you can charge. Of course, if you are a fresher, you are a beginner, you should charge less. Okay, and if you have the expertise, like of course, I think your client won't mind if you are paying, if they are paying you good amount also. Any other question, ma'am?
How much does it cost to file trademark registration in India? I think you have covered this.
Yes, ma'am. That is, I have told you 4,500 in the case of individual and sole proprietor, and for any other cases, that is 9,000. And there is also if any client is in hurry, okay, they want ki like madam jaldi se certificate aa jaye, there is an option of expediting of trademark. Okay, and CAs can also file it in the name of client. The fees for expediting application, that is 20,000 in case of individual and single firm, and other cases it is 40,000. Okay, so as per the situation, they can ask client, if client is in hurry, they can ask any amount.
That's it, ma'am. Only two questions.
Yes.
So thank you so much for a wonderful session and such a good guidance on this IPR.
Thank you, ma'am.
So
Thank you so much for
thank
inviting
you
me.
all for this patient listening.
Thank you.